thank you everyone for joining us today for this webinar. My name is Jie Huang. I am a senior associate at Scott Legal PC. So today we're going to spend some time talking about how to obtain a green card based on employment. And so we're going to talk about how the pathways through which you can obtain a green card based on company sponsorship that allows you to live and work permanently in the United States. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a week on different immigration law related topics. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. So first, we will send you a copy of the PowerPoint that has all the information that will be covered in this webinar. Second, we will send you all a comprehensive guide to the visa types that we will be discussing today, which is a booklet of information that you can use as a reference. We will also send you a link that you can follow so that you can sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button as we regularly upload a variety of immigration law related videos that can be helpful to you. And we'll also send you a link that you can follow to set up a consultation should you wish to discuss your case in further detail. So today we're very lucky to have Kelly Wiener, who is a partner of Scott Legal with deep expertise in the employment-based green card pathways, who will be presenting about the options available to you to obtain a green card based on employment and what are the main considerations. Finally, for any questions you may have, you can feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, GA. So we're going to run through the employment-based green card options. The ones that we're going to cover in most detail are ones related to the PERM, the EB2 and the EB3, but we'll briefly touch on some of the other categories. So one is the EB1A Extraordinary Ability Green Card. This is for people who have risen to the very top of their field and can demonstrate sustained national or international acclaim. So very high standard to meet. Sometimes people who are on a temporary visa called an O might eventually transition to this green card, although you don't need to be on an O to apply for it. We also have a webinar that specifically covers this green card, in detail. There's also the EB1B for outstanding researchers and professors. This is generally for people who are coming to the U.S., for tenure track positions or for research. The EB1C multinational manager or executive is, for people who are coming from a company abroad, to hold a managerial or executive role in the United States. The EB2 has kind of 2 subcategories. So under this category, you need to demonstrate you have either an advanced degree, which means a U.S. master's degree or higher, or the equivalent, which would be a U.S. bachelor's plus 5 years of progressive post-baccalaureate work experience, or exceptional ability, which is kind of a lower standard than extraordinary ability. But you still need to demonstrate that you are kind of above, normal accomplishments within the field by proving you meet at least 3 out of 7 criteria. Once you've met that threshold requirement for the EB2, then there's 2 pathways to get the green card. One is through the National Interest Waiver. So this is where you are waiving the normal PERM process. So the normal process is company sponsorship by a U.S. company. The National Interest Waiver is where you essentially ask the government to waive that sponsorship requirement by demonstrating that you are engaging in an endeavor that has substantial merit and national importance, that you yourself are well positioned to advance the endeavor, and that on balance, it's beneficial to the U.S. to waive this normal, labor certification company sponsorship requirement. So again, quite a high standard to meet. For the PERM, we're going to talk about this more in other slides. This is company sponsorship. So this is where a U.S. company will sponsor a foreign national for kind of a permanent role in the United States. The EB3 is similar. US companies going to sponsor you. There's three categories: professionals, which means the job requires at least a US bachelor's degree, or skilled worker, which means the job requires at least 2 years of education, training, or experience, and unskilled workers. So that's anything below that 2 year requirement. And there's less green cards available for that unskilled workers category within EB3. EB4, so this is a special immigrant category that touches many areas. For example, religious workers who are transitioning to a green card would go through this category. And then EB5, which is an investment-based, although it's in the EB category, it's investment-based. This is where you're going to invest either 800,000 or $1,050,000, and you have to prove that you're going to create 10 full-time jobs in the United States with that investment. So that's, we also have other webinars that go over the EB5 in significantly more detail. All right, let's talk about the PERM labor certification process. So the PERM is the process by which a U.S. company can sponsor a foreign national for a permanent role in the U.S. It is a three-step process, and the PERM part is kind of the longest part. We'll go over the timelines a little bit later, but basically you will need to draft a PERM compliant job description. And what this means is that you can only ask for the minimum requirements to do the job in a reasonable manner. Most job descriptions are going to say, excellent communicator, great team player, things like that. But for the PERM, what they want is for the employer to really distill, if I had to hire somebody off the street, tomorrow, what would be the minimum requirements that they would need to do this job in a reasonable manner? And then you will kind of draft the job description based on that, as opposed to asking for kind of subjective, factors that, in the process. Once the job description is drafted, you will file a prevailing wage determination with the Department of Labor. These are taking about 6 to 8 months to come back. This is where you're going to submit the job title, the requirements, the job duties, and the Department of Labor will come back and they will issue an occupation code and the prevailing wage, which is the minimum wage that will have to be paid once the green card is granted in the future. Once you get the prevailing wage, you can start the recruitment process. So this is where the company will actually have to test the U.S. labor market. They'll have to place advertisements. There are regulations that govern what types of advertisements will need to be placed. For example, if it's a skilled workers job or unskilled workers, you only need to place advertisements in 3 locations. If it's a professional's job or higher, then it will need to be in 6 different locations. And again, these are all kind of regulated, so it's not kind of a normal recruitment process. The employer can't just post where they normally post. They will be required to post in various different areas. For example, in the newspaper of general circulation where the job is going to be located, in the state workforce agency where the job is going to be located. And then there's also a list that they can choose for the additional 3 advertisements. The recruitment process is, 60 days at least. During that time, the employer actually has to review resumes, see if there's any willing, qualified, and available U.S. workers for the job. If they do find any, then the PERM process does have to stop. If they don't find any, then they can go ahead and submit the labor certification once the labor market test has ended. The labor certification, form basically says, here's everything we've done. Here's the proof of, we've advertised in these places. No documentation is submitted initially. It is an attestation-based system, which means the employer is signing that they have done these things and providing the information. The government can either certify the labor certification, which means approve it. They could also deny it, or they can audit it. And if they audit it, then what they're going to say is, we want you to send us all of the proof that you actually conducted this labor market test. Send us all the resumes, send us all the evaluation sheets, send us business necessity documentation that proves why you need 10 years of experience to do this job in a reasonable manner. And so it's important to know, what are the audit triggers? What might make it more likely for your case to be audited? And there are kind of trends. So in certain years, they'll focus, there was a trend for years where they focused on unskilled workers cases. And there was, so they do kind of go through various trends, but there's some consistent things that might trigger an audit. One would be any foreign language requirement, because this would obviously be an easy way to eliminate a lot of US workers from the job pool. There's very high standards for including a foreign language requirement. If it's not a job that's, for example, a Spanish teacher, that can be very, very difficult to get those types of perms through. Similarly, any requirements that are outside what the Department of Labor considers as normal for the occupation can trigger an audit. So they have pretty, strict parameters that they use for this. If the employer really insists that you need 15 years of experience and that's the minimum requirement, the employer will be, asked to document that that is a business necessity for this type of role. So all of the PERM filings are happening with the Department of Labor, not with the U.S. Citizenship and Immigration Services, so not with the immigration authorities. In terms of timing, as I mentioned, it can be quite a long process. It's 6 to 8 months to get the prevailing wage determination, about 2 to 3 months for the recruitment process. And then the bulk of the timing is really the time they're taking to adjudicate the actual labor certification. Right now, it's about 15 to 16 months. So as you're considering this process, you have to take into account that just between the prevailing wage determination and the labor certification timelines, you're already looking at over 2 years of just waiting while they are processing these cases. So that's important to keep in mind, as for underlying status, if you want to be in the United States during your green card process, and we'll talk about that later in the presentation. Once your perm is approved, then you move on to the I-140 stage. The I-140 is a form that is filed with U.S. Citizenship and Immigration Services. It's filed by the sponsoring employer and basically says, we want to sponsor this person for this job. Here's the salary. Here's where they're going to be located. And with the I-140, you're going to also file proof that the employer has the ability to pay the prevailing wage or the offered wage. So the offered wage has to be at least at a minimum the prevailing wage, but sometimes it's higher. If it's higher, the employer will have to show they have the ability to pay that wage. And they have to prove they have the ability to pay it from the time the perm is filed. So important to keep that in mind. You want to you want to look at the financials even before you file your perm, especially now that these perms are pending for over a year. They will ask for the tax return and the documentation to prove that the company had the ability to pay, and still has the ability to pay. You'll also have to file the I-140 with proof that the applicant, the foreign national, meets all the requirements in the job description. So if you've asked for a bachelor's degree and 10 years of experience, you'll need to provide the proof of that applicant's bachelor's degree and then employer experience letters from experience they gained prior to joining your company, except in limited circumstances. And so that is all part of the I-140. The benefit of the I-140 is you can pay for premium processing. You can get an answer within 15 business days. The answer can be an approval, denial, or request for more evidence or notice of intent to deny. If it's, two of those latter, you prepare a response and then they'll issue a final decision after that. If you don't opt for premium processing times are taking, about a year, give or take. Once the I-140 is approved, we move on to the third step, which is the green card step of the process. So this is where the foreign national will actually file for their green card. That can happen two ways. One is in the United States through the adjustment of status process. That involves filing an I-485. And you can also file for work and travel authorization along with that. The other option is consular processing. That's where your green card is going to, the I-140 approval gets sent to the National Visa Center, and then that gets sent to the U.S. consulate in the country where you're living or the country where you previously lived before you moved to the United States. We have a section here about timing and if something is current or not. So right now, the EB2 and EB3 categories are backlogged worldwide. What this means is that once you get to the I-140 stage, very often there's going to be some type of wait before you're able to actually file your green card application. It may not be that long of a wait because your priority date for PERM is set on the date your PERM is filed. So kind of if it ultimately is approved, you're already kind of waiting a year and a half. So during that time, there's kind of built-in waiting time, and maybe it's only a few months before you can, file your green card application. Unfortunately, we do anticipate these backlogs will continue to grow because there is many, many green card applications, and the government is not raising the number of employment-based green cards that can be issued in any given year. So that is creating a long backlog. So you, again, like this is something we'll talk about later in the presentation, but you want to be thinking strategically if you want to be in the United States during your entire green card process. You want to think about what visa are you currently on? Can you continue to renew it? Are you able to spend some time outside the United States? Because until you file your, your green card application, your adjustment of status application, you're really not able to stay here on the basis of the green card process. Filing the I-140 doesn't give you any status. Similarly, if you're going through consular processing, that process doesn't give you any status in the US. So if you want to be in the US, you have to be, thinking about what temporary visa you would want to be on. Um, in terms of family members can join. So your spouse and any unmarried children under 21 can join your green card process. If your children are kind of getting to, older, you want to be very thoughtful and discuss with an attorney about their age and kind of what process you're going to go through, because that can impact whether they're able to join your petition. All right, let's talk a little bit more about the differences between adjustment of status and consular processing. So as I mentioned, with adjustment of status, you're going to file a form called an I-485 with U.S. Citizenship and Immigration Services. You must be in the United States in a valid status that allows for an adjustment to take advantage of this option. If you are able to do this, then the benefit is you have the ability to remain in the US based on the pending adjustment of status. You can also file for work and travel authorization. And then at the end of the process, you'll have an interview with the USCIS officer. It used to be the case that many employment-based interviews were waived. We're seeing that happen less, these days, and certainly with the executive order asking for, maximum vetting of all foreign nationals, we anticipate more interviews. At the interview, we'll talk about this a little bit more later, but they're going to ask about the job, your immigration history. So you do want to make sure that you've gone over all of that in detail with your attorney because they will look back to make sure you've maintained your status every single time you come to the US. With consular processing, your I-140 will be approved and then it's sent to the National Visa Center. You'll fill out an online form called a DS-260 and you'll submit your biographic documents to the National Visa Center. Once they determine they have everything they need, they will send the file to the US consulate and then the consulate will schedule you for an interview. It can take a while to be scheduled for an interview. It will depend on kind of consular availability. Most of the backlogs from COVID are resolved, but there is still delay. So you want to kind of think about that. If you're going through consular processing, you will attend an interview at the consulate. If you're approved, they'll put an immigrant visa stamp in your passport that's valid for 6 months. You'll need to enter the US while that's still valid. You'll be given a stamp in your passport that identifies you as a legal permanent resident. It's called an I-551 stamp. And then your green card should be mailed to you within 60 days. For people that are working in the US, maybe on an E2 status, or an O1 status, who need to travel frequently and kind of can't wait for work and travel authorization to be granted. Sometimes they might choose this option. So there is, different strategy reasons why you might choose this option, even if you're kind of living and working in the US full time. That being said, the vast majority of people who are living and working in the US, if they're able to, will go through the adjustment of status process because it does give you that ability, to stay where you're currently living and working with your family. Your spouse and your children can also apply for work and travel authorization when you all file the I-485. Who can pay for green card fees? So this is a very common question, and it's very important to know that any fees related to the PERM process, legal fees and otherwise, must be paid by the sponsoring employer. We certainly have had people come to us and ask, can I think my employer is willing to do it, but he's only willing to do it if I pay for the process. Is that possible? And the answer is no. For policy reasons, the government does not permit the employee to pay all the legal fees and the PERM fees related to sponsoring somebody for a green card. Once you get through the PERM and you get to the I-140 petition and the green card petition, it's more flexible. And at that point, the foreign national or the employer can pay those fees.
All
All
right.
right.
Thank you, Kelly. So I'll take over a little bit and talk a little bit about some various strategic considerations, and then I will turn it back over to Kelly. So let's talk a little bit about dual intent. And we've briefly mentioned this in some of the earlier slides, but what is dual intent and why is it important to consider this? So So the thing is, for many non-immigrant visas, dual intent is not allowed, which means non-immigrant intent is a major part of visa eligibility. And this means that every time you apply for a visa or try to extend it for some categories of visas, non-immigrant visas, applicants must show that they actually do not intend to move to the United States permanently. Now, by contrast to that, if a visa category has dual intent, that means applicants actually do not have to prove that their intent is temporary, and actually it is okay to have immigrant visa petitions going on in the process. So which visas have dual intent? There are only a limited number of visas that have this privilege, and that is the H-1B visa, L visa, and also the O visa. So in those types of visa categories, if you have a green card process going on in the background, that is okay. You will still be able to continue to have and renew such visas. So when you are thinking of, working with your employer to, start the PERM process, file the I-140 and consider all these steps that Kelly mentioned earlier, definitely it is important to note first that what is your current non-immigrant status, and does that current non-immigrant status allow dual intent? So let's talk a little bit about the strategic considerations when you are moving from a non-immigrant visa to a green card. So timing and underlying visa status is definitely very important considerations. So when you're considering engaging with this process, consider how much time is left on your current underlying visa first. Because, as I mentioned before, some visas that do not have dual intent, those are harder to extend or maybe subject to more scrutiny once, an I-140 petition, for example, or green card petition is filed. And one example of a visa that is quite strictly scrutinized for non-immigrant intent, or examples include the TN visa, for example, or the F1 student visa. Um, those types of visas have an emphasis on the applicant to prove non-immigrant intent, and depending on where you are in the immigrant visa process, being part of that process can complicate things. Now, the other strategic consideration to ask is, do you want to adjust status in the United States by filing an I-45, or are you planning to get the green card through consular processing? And Kelly went over some of the strategic considerations that come into this. One of the major questions is preserving the ability to travel internationally. So if you are someone who is on an H-1B, for example, or O visa, and you do need to travel internationally continuously, filing the I-485 in the United States could create a period of time where you're actually not able to travel outside the United States. So doing consular processing may, be a strategically wise choice. By contrast, if you want to continue living and working in the United States, and if that is your priority, and let's say, you don't know how much longer you can extend your current underlying visa status, then filing the I-45 could be a good option, because you can continue to live and work in the United States by virtue of having filed the I-45. If you can apply for the employment authorization card based on the pending I-45. You can also apply for travel authorization for if you would want to travel while the I-45 is pending, although that can take quite a few months to be approved. So definitely speak to an attorney to really get a good sense of the timing considerations once you do file the I-45. But the I-45 could be a good option if you are looking for ways to extend your stay in the United States, even if you don't maintain an underlying non-immigrant visa status. So the final strategic consideration you want to really think about is family considerations. So if you have children who may also need the green card, definitely it is a good idea to consider filing for the immigrant visa petition early to avoid issues with the child aging out at 21, because at that point the child will no longer be eligible for a derivative green card based as your dependent. All right, so now from here, then I will move it back to Kelly, and she will take us through some of the other considerations.
Thank you. So we're going to talk about the green card interview. Some employment-based applicants may not need to attend an interview if they're doing an adjustment of status, although we expect that most will need to attend interviews, at least for the next, few years. If you're going to a consulate, you will always attend an interview. There's no ability to waive that. What should you consider before you go? So one is you want to review your immigrant visa petition and your green card petition before the interview. By the time as you can see, this is quite a long process. By the time you're called for your interview, perhaps certain things have changed in your job or there have been adjustments. You want to make sure that you're very familiar with what was, written. If you're making any argument that the job has changed and you are porting, we'll talk more about porting later. Because your green card's been pending for at least 6 months, you want to bring, arguments and documents related to that. So you want to just be very familiar with everything that's written in there, including your immigration history. You want to organize and print your documents to bring to the interview, get your original documents and also a copy. So, the field office should have the entire petition. That being said, sometimes they're missing documents, they're looking for something, they don't have it. Always better for you to be able to say, here's a copy of the birth certificate and here's the original. Um, Better to be prepared with that information, even if you don't end up using it. Always good to have it. You want to make sure that the I-693 medical exam is completed. If you're doing this at a consulate, you'll go to a panel physician and ahead of time, and usually they will arrange to, mail the medical exam, to the office that's reviewing it. Um, you want to get updated proof of employment from your sponsoring employer. Usually this is going to be, employment verification letter or the I-485 Supplement J also contains the same information. If you're currently working there in that same role, you could also bring, pay stubs, so proof of maintenance of status. If you are adjusting status in the US, it is a requirement that you show that you have maintained your status on every prior entry to the United States. There is an exception for employment-based applicants where, let's say, in prior years when there were no grace periods available, for workers, maybe you had a couple days out of status when you were fired unexpectedly on an H-1B. Technically that would prevent you from being able to adjust your status, but there is a provision in the law that allows you to still adjust status as long as you have not, violated status for more than 180 days since your most recent entry. So this, again, it's very important to be candid with your immigration lawyer about your entire immigration history, because they will look at everything when you are, adjusting status in the United States. Also a good idea to meet with your attorney and do a practice interview. Even if you feel very comfortable, people may feel that way. And then when you get into the interview, you may feel nervous. So always better to have at least practiced or thought about what are some of the questions they may have asked me. While there are many very professional, very courteous officers. There are also others that take a bit more of an adversarial approach, and you do want to be prepared for both circumstances to be able to explain why you meet, the requirements to be approved for the green card. All right, what is porting? So a very common, question people ask is, can I change employers during the PERM process? And, can I continue with my green card? At many stages of the PERM process, let's say your employer just started a PERM, for you, and you find a really great new opportunity and you want to go there. You don't retain any benefit from the fact that they filed a PERM for you. However, if you get through the process and your I-485 has been pending for at least 180 days, you do then get the ability to port. So it does mean the I-140 that was pending or filed does have to be approved. But porting means that a new employer will not have to complete a PERM. They will not have to complete an I-140. What they will need to do is show that the new employment is going to be in the same or a similar occupational classification as the job that was offered to you in the Form I-140. So let's say your green card process was for a, VP of accounting role, and, now you really want to go become a bartender. That's not going to work, right? It's too far apart. That being said, if, now you're being hired, to be a CFO somewhere, that may be able to work. So you do want to kind of do that analysis, but it is a benefit that you get only towards the end of the green card process. But if you do get there, and your I-485 has been pending for that 180 days, porting would be something that's available to you. All right. Can I change employers after I get my green card? Another very common question. Sometimes people are staying with employers for a very long time because they're trying to get that green card. They want that certainty. And then once they have the green card, this permits you to work anywhere. And so they may, want to start their own business or, do a side business or do something else. When you obtain this employment-based green card, you are making a good faith attestation to the government that says you plan to continue working for the company sponsoring you in a permanent role. That does not mean you are required to work there forever. But it also does mean that you would not want to immediately, the next day after you get your green card, quit that job unless there was some, real extenuating circumstance that explained it. There's again nothing that prevents you from doing that. However, if you do ultimately decide you want to become a U.S. citizen during the naturalization process, they will look at your history and ask questions. And so if they do see, well, you got a green card and then the next day you left the job, that could raise questions for them about whether there was any misrepresentation or at the bare minimum, what happened, what was the story there. So, generally it is a good idea to stay and work for that company for at least a few months. If after that you get a great new job offer, or your spouse was transferred to another state, or there's some, reasonable, reason why it is that you change jobs, that's okay. But it's not a good idea to kind of immediately quit your job, the second you have your green card in hand. All right. I don't believe that we have any questions. So I think we will end here. Thank you everyone for joining, and I hope everyone has a wonderful day. Thank
Thank
you.
you, Kelly. Thank you, everyone.